Hello, welcome to Learning Law and this Company Law Part 5. We are going to discuss statement in lieu of prospectus, role of promoter, and pre-incorporation contracts. Statement in lieu of prospectus. A statement in lieu of prospectus is a document filed with the register of companies when company has not issued prospectus to the public for inviting them to subscribe for shares. When a company is not inviting public to subscribe with shares through issuing of promoters, then that company should file statement in lieu of prospectus with the registrar. And the statement must contain the signature of all the directors or their agents authorized in writing. Next, role of promoter. Promoter is any person who complies with the necessary formation of formalities of company's registration, finds directors and shareholders for a new company, acquires business assets for use by the company, and negotiates business contracts on behalf of the company. The promoter has many responsibilities like preparing a prospectus, signing new agreement, trading in stocks, as well as other goods. A promoter is a person who is necessary for he carry overs the every process of registration until incorporation, and he manages the assets of company, negotiates business, preparing prospectus, and these are the role of promoter in a company. Pre-incorporation contract. A contract that are made on behalf of the company by the promoters, incorporation of company for gaining some rights and company, and that contracts are called as pre-incorporation contract. Pre-incorporation contracts are contracts which are entered by the promoters before the incorporation of a company. It is the purpose of pre-incorporation contract is uh, for incorporating a company or for carry over a business. So before incorporation, a pre-incorporation contracts are entered by the promoter. Pre-incorporation contract are those contracts that are necessary to run a business or incorporation. When promoter makes pre-incorporation contract, the company is just an artificial entity, which means at the time the company does not exist. So basically, it cannot be executed at the time of incorporation. As after incorporation, the company comes into existence and it is an artificial person. So before incorporation, company does not exist. So there is no binding force on company as of now. Then enforceability of pre-incorporation contract. According to contract act, pre-incorporation contract are not valid. As the formation of any contract, there should be two parties, and in case of pre-incorporation contract, the company is not incorporated at the time, so it cannot be a party. Therefore, the enforcement of pre-incorporation contract in India comes from the Specific Relief Act 1963. Section 15 clause H of Specific Relief Act 1963 says that when promoter of company forms a contract for the purpose of company before its incorporation, it is said that the company has accepted the agreement and warranted it and also communicated to the other parties. So, according to Specific Relief Act, a pre-incorporation contract is entered by the promoter. Okay. After incorporation, in memorandum of association, it should be declared that yes, we are accepting the pre-incorporation contract, and also after incorporation, the company should declare that it is bound by the pre-incorporation contract, and such acceptance should be communicated to the other parties. Then such pre-incorporation contract are binding on the company. Thank you for watching this video.